Hello, my name is LEXCLIQ and I'm an intern at LEXIS and Co. I'm a third year law student at New Law College, Pune, and the topic for the day is types of injunction under the Indian law, part 2. We left at permanent injunction, and this is how it goes. The court can issue a permanent injunction by issuing a decision at the hearing and based on the merits of the case. Once such decree is issued, the defendant is permanently barred from asserting a claim or committing an act that would be violated of the plaintiff's rights. A permanent injunction is issued on the following basis: to the plaintiff in a lawsuit brought to prevent a breach of responsibility owed to him, whether implicit or explicit, in cases where such a duty comes from contract. However, the court must follow the rules set forth in Chapter 2 of the Act. Section 9 of Chapter 2 states that the person may seek contract remedies by arguing in his defense on any grounds accessible to him under any legislation relating to the contracts. The court may grant permanent injunction in a case when the plaintiff infringes or threatens to infringe on the plaintiff's right to or enjoyment of property. The plaintiff's property is held in trust by the defendant. There are no criterion for demanding the real harm inflicted by the invasion or likely to be caused by it. The invasion is such that monetary compensation would be insufficient to provide adequate relief. The injunction is required to avoid a slew of judicial actions. Mandatory injunction: if the court determines that it is essential and within its power to force the performance of an act in order to avoid violation of an obligation, it may do so by issuing mandatory injunction to the plaintiff. Requiring the defendant to undertake the required acts, the court can issue an injunction prohibiting you from doing specific things that the contract prohibits from doing, even if it is unable to compel the defendant to perform the affirmative conditions of the contract. That is, the clause that requires the defendant to perform specified acts, the court may do so. However, where the plaintiff has performed the terms of the contract binding on him or not is a reality, the plaintiff is barred from seeking such injunction if he fails to perform. An injunction can also be rejected on the following grounds: to restrict a person from prosecuting a pending legal proceeding unless it is to avoid the proceeding being duplicated. An injunction prevents a person from starting or litigating a legal action in a court where the injunction is requested from a lower court, to prevent anyone from submitting an application to the legislative body, to prevent someone from bringing or prosecuting a criminal case, to prevent a breach of contract whose execution is not particularly enforced. For example, a contract between a master and servant requiring the servant to offer personal service to the master cannot be specifically enforced by which is the master or servant. As a result, an injunction cannot be obtained in this case. To prohibit an act on the basis of nuisance when it is not sufficiently evident that it constitutes a nuisance. To avoid a continued breach in which the plaintiff has acquiesced, as the common rule is acquiescence and is the same as implied assent. Except in the situation of breach of trust, equally effective relief can almost always be achieved through any other common means, when the plaintiff or his representative have acted in a way that disqualifies him from receiving judicial aid, when the plaintiff has no personal stake in the outcome of the case. This is all for the types of injunction under the Indian law and how it protects you. Thank you and have a great day.